Hello? Can you hear me? I don't really think I need this mic for you to hear me, but we are recording this. So for the very few of you who may not know who I am, I'm Professor Hoffman, and I am the director of the Bradley Fellows Program in Criminal Law at the thanks, Kevin, at the IU Maurer School of Law. This is our sort of signature event of the spring semester, a chance to have a conversation with the Solicitor General of the state of Indiana. So we'll get to that in just a moment. But before we do that, a few quick announcements. Obviously, feel free to go back and help yourselves to more pizza. We did not know that someone else would, at the last minute, schedule an event against us. So there's probably more food in the building today than students can reasonably eat, but don't be shy. I understand that some of you have to get up and leave the room for journal photos. That was another thing unanticipated because it rained last week. We've told Mr. Fisher it's not a commentary on his words here when people do get up and leave, but please do so quietly and then return quietly. Even Alex, our sort of co-host today, is going to have to do that, which is not the only reason you were dressed up, but probably one of the reasons. The Bradley Fellows Program in Criminal Law is a program that we started last school year. This is the second academic year for the program. It's named after the beloved crim law professor Craig Bradley, who passed away a few years ago, my dear friend and senior colleague. The program is designed to help our students who have an interest in criminal law, either as prosecutors or as defense attorneys, to enhance their education, their training, their experience. In particular, for those of you who are currently 1L students, we will be encouraging applications for the Bradley Fellows Program at the end of the 1L year, or at any time thereafter. We certainly welcome people joining the program at any point, but there are requirements, curricular requirements, extracurricular opportunities and requirements, externships that are special and unique to the Bradley Fellows Program, even international opportunities. We do a lot of work with colleagues abroad, especially in recent years. We've been working with some colleagues in Poland, and we've been holding some comparative criminal law events. Can I get the Bradley Fellows who are here at the moment to stand up, please? So these are some of our wonderful Bradley Fellows, and I encourage you to talk to them if you have any interest at all in the Bradley Fellows Program. Thank you. So one of our most active Bradley Fellows is Alex Van Dyke. Alex has been working as a clerk. Did I get that right? Clerk is the title. Has been working as a clerk in the Indiana Solicitor General's office for, I think you said, more than half of your time in law school, 2 summers as well as 2 semesters of internships. Partly or largely through Alex's efforts, we've been able to bring our guest speaker here today. Alex is going to be going from Maurer this year to a clerkship at the district court level for a year, and then just recently, a few days ago, learned that he will be following that up with a clerkship at the U.S. Court of Appeals level. So wonderful job, Alex. Congratulations. We're going to do this as an informal kind of question and answer session, and we're going to try to leave some time at the end for you to ask questions as well of Mr. Fisher. But I'm going to turn it over to Alex to do the introduction of Mr. Fisher and also to start the Q&A, and then I will take over from there.
Thank you. So I have the incredible honor of introducing our speaker this morning. So Solicitor General Fisher is a graduate of this law school in 1994. He went on from that to clerk also for the U.S. Court of Appeals, and then spent some time in private practice before in 2005 becoming Indiana's first and to this date only Solicitor General. The case we're going to talk about this morning is a case that Mr. Fisher was able to argue before the United States Supreme Court last November, entitled Timbs v. Indiana. And I don't want to preempt any of what Mr. Fisher might say to you this morning, so I'm going to let him give a lot more details on both of those things. But I do want to say that, as Professor Hoffman said, I've had the great pleasure of working for Solicitor General Fisher throughout most of my time in law school, and he's an incredible mentor to me. So please join me in giving him a warm welcome this morning. Okay, so I'm going to just start with some background information before I let Professor Hoffman take a lot of the questions for the Timbs case. But I did want to know from you a little bit more about how you became Solicitor General, what your path was there, particularly maybe some information about your experience with appellate law leading up to that position.
Sure. Wow. So, no. Good. All right. Where to begin? Well, as Alex mentioned, I was able to clerk at the federal appellate level coming out of law school, and that was huge. It opened up doors that I didn't even know existed, let alone even had tried to open otherwise. But one of those doors was a very big one at Jones Day in D.C. through Greg Castanis. Many of you know, I'm sure know Greg. It seems like everywhere I go, either here or Wabash, both of which we are alums, everybody knows Greg Castanis. And I had the incredible good fortune to be recruited by Greg to go to Jones Day, 20-some odd years ago. And that introduced me to the field of appellate law sort of even more than I had ever understood it before. I was in a group called Issues and Appeals at Jones Day, which had a lot of former U.S. Supreme Court law clerks. I couldn't believe there's no way I could get a job there now, quite frankly, because they hire so many. They hire like more than half the Supreme Court law class every year. But back then, they were still trying to get off the ground a little bit, and little old me found a way to get in there. And I learned a lot from Greg and others about appellate law, about Supreme Court practice. I had always had an interest in constitutional law, and Alex probably remembers this a couple of weeks ago. I actually gave an introduction to someone who was a mentor of mine along the way, but oddly enough, I never had a chance to work with him. This is a guy named Jeff Sutton, who is a judge now on the Sixth Circuit Court of Appeals. Well, Jeff had been a young associate at Jones Day, just ahead of me before I'd gotten there. And when I arrived at Jones Day, he had just left to become the Ohio solicitor. And he was all the talk of the Issues and Appeals crowd at Jones Day. And they were talking about what a neat move it was for Jeff to go do all of this. He was from Columbus. This was going to enable him to get Supreme Court arguments, and it was going to be a really great sort of career move. And I thought to myself, what? Wait a minute. States have solicitors and solicitors general? I had no idea. This is nothing that had ever occurred to me before. And so I got to know Jeff over the years. I watched his career develop a little bit. After a few years, my wife and I moved back to Indiana. I went to work at what's now Faegre Baker Daniels, another terrific law firm. Really enjoyed my time there, and had another mentor in that environment who had worked in the Indiana Attorney General's office, another alum of this law school, a guy named Matt Gutwein, who is now the CEO of Marion County Health and Hospital. So Matt has had a remarkable career both in the law and in hospital administration, and just generally he's a sort of a Renaissance man in many ways. But Matt had encouraged me to look at AG law and he and I worked together on some appellate cases and some Supreme Court cases, and he further developed that interest that I had. I was able to do some appellate work at Faegre. It was really a balance between general commercial litigation and the things that pay the bills, and then the things that I really enjoyed that were more sort of public law oriented. Then, as luck would have it, in 2000, another mentor of mine, a guy named Steve Carter, got elected Attorney General, and I had known Steve since I was in college when I had interned in the Lieutenant Governor's office, and he was the chief of staff there. And I convinced him that I should, be a part of his new administration coming in, and I had these, special skills that I developed in this, esoteric world of Washington D.C. And he bought it hook, line, and sinker, and brought me in and gave me really. I had a title of special counsel, and it was kind of it was an odd portfolio. At the time, the national tobacco litigation had just come to settlement in '98, and everybody was still trying to figure out what do we do now with this settlement and how do we administer it. And Steve basically said, okay, this is part of your portfolio, figure it out, and let's go from there. And I quickly figured out that I wanted somebody else to do it. So I recommended him that we figure that, we offload that, and we did that after a couple of years. But I was able also to make part of my portfolio the range of cases I found most interesting. So mostly constitutional cases, oftentimes appellate, but not always, sometimes in district court, but just public law issues that I was really, really clamoring for when I was in private practice were finally there in front of me, and I was sort of, trying to get all that I could. Carter got reelected in '04, and state government being the way it is, he couldn't really afford to give me a big raise to keep me around. So he did what all good bureaucrats do, which is he gave me a fancy title. And so he created the Solicitor General spot and was gracious enough to bestow that title on me. And over time, I've been able to work with both Carter and then his successors, A.G. Zeller and A.G. Hill, to build out that division of the office. It's not enormous. I just have, it's me and two other full-time lawyers, but then we bring in talented people like Alex and others that come in and help us out. And we've been able to handle a fair number of interesting and important cases, Tim's being one of them, and it's all worked out even better than I ever kind of hoped. I will take you back, though, as I conclude this point, to the fall of my 2L year. Everybody knows what you do then, right? You're interviewing with the law firms, you're getting ready for you want to land the big summer associate job. It's a high pressure time. You're doing your law journal stuff. You're trying to keep your grades up. Everything's and I went through the interview process like everybody else, and I learned the lines and I learned the script that you're supposed to go through and trying to convey how you're going to land the job and what it is that you're interested in, the firm happens to be offering. And I got to tell you, by the time I got towards the end of it, I was starting to lose my focus on what my lines were supposed to be, and I was starting to actually speak from the heart a little bit, and that could be kind of dangerous in that situation. But I wound up with a firm that I was only marginally interested. I think they were only marginally interested in me. It was just it wasn't going to be a great fit anyway. And they asked what I wanted to do with my career, and it was one of those moments. I just I'm going to be honest. I said, I really want to do constitutional law, and I really want to argue cases in front of the U.S. Supreme Court. But the only place you can really do that is the U.S. Solicitor General's office, and I don't see much chance I'm going to go there, so I don't really know how that's ever going to work out. So I guess I'm talking to you guys instead. I wasn't quite that cross, but that was the basic drift of it. And I was like, okay, next. Well, here I am, so many years later, and I didn't, go what I thought was the only route then. I found a different route, but I've been so fortunate with all the great education I got here and all the great mentors I've had here, including Professor Hoffman, to turn my vision as a quite callow 24-year-old at that point into somebody who's had 4 arguments now in the U.S. Supreme Court and trying to find the next one. So
can I know you have a few more questions, but can I just jump in and point out the takeaway lesson here for law students? And this is not just peculiar to law students, of course, but Mr. Fisher basically made his own job. He basically created his own job. If you wait for a job to exist and you get in the line of 100 people trying to get that job, that's a tough slog sometimes. But if you know what you want to do, this is kind of proof, you can sometimes make your own job happen.
Well, a question as a follow-up to being in that job now. For those of us who may not know, just what exactly does a Solicitor General of a state do?
The state SG model is not a singular model around the country. There are some state SGs that are statutorily created. I'm not. And candidly, the ones that are much older. They tend to have originated in their roles from the early 20th century. So a lot of antitrust-related history to all of that. And there's only a handful of them. Most of them originated in the past 35 years, and some have supervisory authority over entire appellate divisions. That comes up mostly in your big states, New York, California, Illinois, Texas. That's not our model in Indiana. Some of the smaller states, some of the more recent states have created SGs. it's more, I don't know, at some level it's sort of a kind of specialized practice within the office that takes, the way we say it anyway in our language, we take referrals from other divisions of the office, cases that fit our certain profile, whether they're novel or particularly important constitutional issues. Sometimes it's a kind of complexity about it or a profile that it has that makes it something where the AG wants the SG involved. But it's a lot of constitutional cases. It's a mix of district court and a court of appeals work. It's a mix of state and federal court, which is really, really kind of neat because if you kind of think of it as a quadrant, trial court, appellate court, state, federal, I've got about an equal balance in each of those quadrants, which is great because I love not only federal constitutional law but state constitutional law. As an aside, next year I'll be teaching state constitutional law in the spring. So if you haven't made out your schedule for that yet, or you haven't figured out what you're taking, keep that in mind.
He's one of our most loyal and talented adjunct professors.
Thank you. But I really enjoy state constitutional law. So being in the state court system and having a regular practice there is a lot of fun because I get a lot of really interesting issues there. So it's also a practice that allows me to advise when called upon other divisions of the office. If there's a strategic question or some strategic help that they might need, I can help with that. I can try to help make sure we're not taking inconsistent positions across divisions of the office on different issues. A lot of times I'm a big fan of trying to make sure we don't waive our sovereign immunity, and sometimes it's harder than others to kind of make sure everybody spots the possibilities for raising sovereign immunity defenses because they can sneak up in some odd areas. So that's a shorthand way of saying we are there to help particularly complex issues, advise on particularly complex issues, but our docket is mostly a litigation docket with a lot of constitutional cases.
That's great. I think with that, I'm going to turn it over to you and let us get started on TIMS.
All right. Sounds great. Thank you, Alex. So, were you involved in the TIMS litigation before it got granted by the Supreme Court? Were you involved in the Indiana courts?
No, I wasn't. I didn't really know about TIMS until the decision came out from the Indiana Supreme Court, and the word spread quickly. Hey, the Indiana Supreme Court just held that the excessive fines clause is not incorporated. And my reaction was, well, candidly, a lot like Justice Gorsuch's reaction, which is, what are you talking about? How in the world? This is 2018. How are we still talking about incorporation? In fact, I've joked, one of the interesting things when you go through a U.S. Supreme Court argument is there are courtroom sketch artists there, and they'll send you a solicitation to buy their sketch or whatever, and I bought a small one, and I'm gesturing like this, and I'm vaguely looking, that Gorsuch is not in the shot, but I'm sort of vaguely looking at him, and I've joked with people. That's where I'm saying, I was just as surprised as you are.
So I just want to know, how many of you have studied the TIMS case, or some of you are in Professor Sanders' class? I know Professor Sanders is speaking in the next room, so I consider it a great honor that you're all here and not with your professor. But some of you have studied the TIMS case recently? Okay. So I think we should start by just giving a little bit of background about TIMS for those who may not be familiar. You've already mentioned incorporation. So for those of you who, for example, are 1L students who may never have learned yet about incorporation, or if you're 2Ls and 3Ls and you learned about it but you've totally forgotten it since then, the incorporation issue involves whether a particular provision in the Bill of Rights, which at the framing or at the adoption applied only to the federal government. All right, this is the key. The Bill of Rights was only a limit on federal government power originally. The question of incorporation is whether any of those provisions in the Bill of Rights should be incorporated into the meaning of the due process that states are required to provide under the 14th Amendment by its terms, which clearly does apply to the states. So at this point, as Mr. Fisher has already alluded, virtually, but not all, not 100% of the provisions in the Bill of Rights have long been incorporated and applied to the states. The specific issue in Tim's was whether a particular part of the Eighth Amendment prohibiting excessive fines should be incorporated. Okay, so this obviously could have been decided, 50 years ago or whatever. Can you've got your
I brought this just as a prop. This is so you make sure everybody knows. This was our brief in the U.S. Supreme Court. Just so if you haven't seen what one looks like, this is what it looks like. The other side's brief, the top side brief would be blue, and then their reply brief is yellow. But ours was red. Red for right on. I don't know. Anyway, and this is a slip opinion, just another prop, just so you can see. This is what the slip opinion looks like. This is what they send you. And typically, frequently, you flip to the back, and there's something that is known as a dissent. I didn't see one in this case. I don't know what happened. I think they must have forgotten to attach it. I'm not really sure what happened there, but anyway.
All right. So, give us a brief summary of what are the facts in Tim's,
Yeah.
and then I'd like you to sort of talk about how you positioned the legal argument that you were going to make in Tim's.
Yeah, and the facts are fairly straightforward. So Tyson Timms was a heroin addict, and his mother sadly passed away, and he was left a life insurance policy of, I don't know, $70,000, $100,000, something like that. And he took about half of it and bought a Land Rover, and he took the other half and developed a heroin habit. And he used the two together. So he would drive the Rover from Marion, Indiana to Richmond, Indiana, nearly every day for over about a 3-month period to buy heroin. Now, along the way, he started to run out of money. So he needed to sell some of the heroin to finance the habit. And he was the subject of a couple of stings, a couple of controlled buys. They arrested him after the second one on the way to the third, and he was prosecuted. And he ultimately pled guilty and received a fairly, not a huge sentence, but something fairly small. But then that wasn't the problem for this case. For this case, what was important was that following the conclusion of the criminal proceeding, the state instituted a separate civil action against the Land Rover. This is called an in rem forfeiture. In rem, the thing, versus, this is a very important conceptual distinction, in rem versus the property, in personam against the person. So the criminal prosecution was against Timms himself in personam, and then the civil asset forfeiture was against the Rover in rem.
These are the cases that have great titles, like U.S. versus $7,283,522.17. That's literally what these in rem forfeitures.
Yeah. No, don't confuse that with U.S. versus $5,235,433, because those two are often confused.
Clearly. Okay, so Timms gets sued by the state.
Mm-hmm.
The Land Rover
technically
gets sued by the state, and this is a civil forfeiture action. So
right.
He loses because
in fact he comes and he. What's interesting about this, it's all after the criminal proceeding has concluded. He no longer has any Fifth Amendment defense to testifying because his criminal liability has all been resolved. And so he ends up testifying at the forfeiture hearing, and he testifies to all these transactions. And it's just a preponderance of the evidence standard. Was this Rover an instrumentality of a crime? And it was clearly the instrumentality of the crimes of purchasing heroin, possessing it, transporting it, and then ultimately selling it, on at least 2 occasions, probably more.
So forfeitures can apply to, obviously, the illegal stuff. Nobody gets to keep their illegal drugs after they're convicted. Mm-hmm. It can also apply to proceeds of the transaction, mm-hmm. right? The money you make from selling the drugs can be seized. Mm-hmm. And in this case, it was the instrumentality, meaning the property you used in the commission. So it'd be like the gun, the car, these mm-hmm. kinds of things.
Right. And historically, the 2 biggest categories of forfeited property are contraband and instrumentalities. Interestingly enough, the proceeds is sort of the one that's been a little bit more modern. Can we actually forfeit the proceeds? And of course, you'd say, well, surely you could, because the ill-gotten gains and all of that. And I don't think there's much doubt about it. But the question is, on what historical theory does that fit? Because it wasn't necessarily part of of the forfeiture that was happening back, in common law. So that's just an aside. But instrumentality. Definitely a core part of historically how forfeitures were used. And this is what this was.
So the Indiana Supreme Court, the lower courts in the Timms case found that although this property was subject to forfeiture under the Indiana statute, that there was a problem with this constitutional excessive fines clause under the Eighth Amendment. Indiana Supreme Court rules unanimously, if I remember correctly, that hey, the Supreme Court's never held that the excessive fines clause applies to the states. They've never incorporated it. So we're not going to say that it applies. That's for them to say. That's for them to say. So the Indiana Supreme Court overturns the decisions of the lower Indiana courts and says, yep, based on what we can say, this is okay. And then the U.S. Supreme Court grants cert. At what point did you find out that the cert had been granted?
Let's see. I don't remember exactly. It was just right. It was the day of grant. I was at my desk, and it was like I think we were. When you do a Supreme Court case, there's a very kind of well-trod path towards how this all happens. You know exactly when your case is set for conference, and you know exactly when the order list is coming out, and so you watch the order list. I've got another.
Had you filed a response in opposition?
Oh yeah.
Okay.
We knew that this was. I mean, we knew all along this was going to get granted. I mean, you don't have a. There aren't too many cases where the lower court says only the U.S. Supreme Court can declare incorporation. Who are we? And then they don't get taken, right? I mean, it's sort of like a
open invitation.
Yeah, right.
Yeah.
Waving the red flag. So we were under no illusions about it. But what was interesting about the case, though, up to that point, was how much each of these the presentation of this issue had been driven not by the advocates but by the courts. Timms never raised an excessive fines defense in the trial court. The trial judge, sua sponte, raised it and said, I think this is an excessive fine.
Because his crime was such a low level.
Yeah. It was what he pled to was one instance, I think, of dealing, and it was a small fine. The whole thing was sort of looked like small potatoes. I think when you look at the larger context, there's more to it, but what he pled to was fairly small, and the judge said this is excessive in relation to what you pled to. And we, the state, never argued that the excessive fines clause was not incorporated. That was never part of our argument. We always said, no, the way you're analyzing proportionality, which chiefly in this case has had to do with the maximum fine. He could have been fined as a maximum of $10,000. And
that was the criminal punishment.
For the criminal side. He wasn't fined that much. That was the maximum he could have been fined. And the judges were saying $45,000 rover or whatever it was worth, disproportionate to that. Mind you, the maximum fine for murder in Indiana is also $10,000. So maybe, some question about whether if Timms had driven his car into a crowd of people, we would not have been able to forfeit it because of the maximum fine. I don't know. Anyway, we're still trying to figure that piece out, but I digress. The issue gets to the Indiana Supreme Court, and again, we're not arguing no incorporation. Indeed, the Indiana Constitution has its own excessive fines clause. So
which wasn't raised by
Timms. So we were never in that position. And then we get this opinion which says basically, wow, incorporation, it's never happened. And, there's this thing out there, apparently the Bill of Rights and the 14th Amendment. We're not really sure how all that works, so we just better let the U.S. Supreme Court tell us. Now, I'm being oversimplifying, but it was kind of an odd thing for a state Supreme Court to say. So the thing comes down, and we look at it, and we think, okay, we can see where this is headed. We do our best to tell the U.S. Supreme Court in our opposition to the cert petition, you know what, this really isn't that important because we and just about every other state, in fact, every other state has an excessive fines clause, so you don't really need to worry about the federal excessive fines clause. I don't know, it didn't really persuade anybody, I guess. So the court ends up taking the case, and there we are.
So how did you construct at this point, you've got to figure out what legal argument can we make in the Supreme Court? Now that they've granted cert on the incorporation issue, you've got to come up with a legal argument to make. Mm-hmm. What was your legal argument?
So there are a couple of different doctrines at work here. One of which, with respect to incorporation, basically whether the right at issue is deeply rooted in the history and traditions of the country. And you look at
because that's what gets it into the 14th
That's
Amendment.
what gets it again. That's the selective incorporation standard the court has been using. Most recently, in the Second Amendment context, at least up until Timms in 2010 and McDonald. And you really have a lot of kind of well laid out doctrine about how all of this is supposed to work. And so that's the standard we're left with. Well, if you look at the historical roots of the excessive fines clause in general, boy, that's pretty tough to make an argument that's not deeply rooted, because you can trace that all the way back to Magna Carta, if not further. And I think all these things came up in the opinion, and there's just not much. I mean, and plus, I think of myself as sort of an originalist, and as somebody when it comes to constitutional litigation, I really like digging into the history, and I'm looking at this thing going, boy, this is not looking good. So the key becomes in these kinds of situations, okay, how thinly can you slice everything? And what we figured out doing our research was we can probably at least have a plausible, colorable argument, something that will not be completely embarrassing if we try to drive a wedge between the in personam and the in rem. All of the historical usage of excessive fines and disproportionality really falls on the in personam side, going against somebody for a criminal fine, and indeed a lot of it has to do with fining somebody so much that they can't pay it and then putting them in jail because they can't pay the fine. That's a lot of the origin of the excessive fines clause, which is not really applicable to in rem, which is all about the property. With in rem, you just go, you seize the property, you forfeit it, and that's it. There's no further liability for the person in relation to that.
Now, the in personam is more closely connected, almost philosophically, to a person's punishment.
Exactly.
And so
Yeah.
it fits with the other parts of the Eighth Amendment and proportionality and so
Yeah,
forth.
yeah. And so there's a really great seamless theory here that I assure you is fully supported by the case law. And yet the U.S. Supreme Court, in a case called Austin back in 1993, had said, for purposes of the federal government, we're going to treat the excessive fines clause as applicable to in rem forfeitures. So it kind of, oh geez, that's a tough break for us. Now we gotta. So basically, we ended up in this position. A couple of parts to this argument. One of which was, hey, this case called Austin, we should just overrule it. It was wrongly decided, and indeed has been undercut by subsequent Supreme Court cases. The original rationale no longer exists. All the sort of boxes you want to check when you go through and trying to get the court to overturn one of its precedents, we thought we could check those boxes. But, it's still a pretty big lift to get the Supreme Court to overturn a precedent. So our next line of attack was a bit more subtle, which was to say, look, we know you have decided, court, to apply the excessive fines clause to in rem forfeitures. But that's not the end of the matter. You still have to answer the question whether in rem forfeitures and a proportionality limit on in rem forfeitures is deeply rooted in the history and traditions of the country. Even apart from in personam and apart from what Austin says about what the excessive fines clause covers, there is no deeply rooted right to a proportionate in rem forfeiture. Because if you go back and you look at all of the forfeiture cases from the common law through the founding period, through the Civil War, you don't see any court until about 1990, 92 saying, oh yeah, we should really start to apply some sort of proportionality test to in rem forfeitures. It's all about, is it an instrumentality or not? And the proof and the arguments all have to do with that relationship, that instrumentality relationship, not with regard to the proportionality between the property, the value of the property, and something about the crime.
Is this the Louisa something case?
The Louisa Barbara. Yeah, the Louisa Barbara. I love the Louisa Barbara. This is one of my go-tos. So Louisa Barbara was a case where there was this, back when most commerce on this, was done on the high seas, and this ship had both cargo and passengers, and there were limits, federal limits as to how much weight it could bear and specific numbers of passengers it could carry. And the Louisa Barbara, this, massive ship with lots of cargo and high, dollar value, was one passenger over the limit. And the entire ship and its cargo were forfeited because it was one passenger over the limit. It's sort of the classic, look, there was no worry there about disproportionality between the offense and the value of the forfeiture. And if that's not a case where you would worry about it, I don't know what is.
If that's not excessive.
What would be excessive? And Justice Scalia well, I'm sure we'll get into this a little bit more in a minute, but Professor Hoffman in our moot was fond of pointing out the scales. Remember the golden scales? The golden scales. What if the crime is perpetrated by use of golden scales to weigh the cocaine or whatever it is? Of course, you can forfeit the golden. It doesn't matter that they're worth millions of dollars. It was
if
an
you're dumb
instrumentality
enough
of the crime.
to use golden scales to weigh your drugs, then you ought to lose.
Then you ought to lose it. Yeah. And in any event, so. If you look at the history of in rem forfeiture, you don't see this history of proportionality deeply rooted. So that was kind of our second line of argument, which is you can't incorporate. You can incorporate perhaps as to in personam. We don't really have any kind of an argument there. But within rem, you've got to be more circumspect. You've got to take into account this history, which favors our side. So that was how we positioned it.
Did you get a lot of help from other states? I mean, you're arguing a position that conceivably affects every state.
Yeah, no, we didn't. We did. Typically in a U.S. Supreme Court case where a state's involved, you'll have no matter whether the issue is more, is more amenable to support from the left or the right, there will be a group that shows up. I mean, there's almost nobody wanted to be seen helping us out in this thing. Of course, we had no friends. The conservatives were like, no, we want to be pro-property rights. We don't want to be, we don't want to be favoring the excessive forfeitures. The left was, sort of just
overreaching government,
all that kind of stuff. I mean, just nobody was. Now, we did have a brief from the State and Local Legal Center, which is basically an association of associations that represents interests of cities and towns and different sort of law enforcement, pro-law enforcement entities. And they had a very helpful brief on the history side, but it really wasn't the kind of impactful thing we think typically you would look for from a state. Texas was interested for a while, but then two things happened. One, they realized that all they really cared about was the disproportionality measurement, not the incorporation question, and so that really they weren't going to be quite on target. And the other thing was that their lawyer who was the most interested in the case got nominated for a federal judgeship and decided maybe this wasn't the case where he wanted to hang out, put it on his resume for purposes of the Judiciary Committee hearing. I exaggerate a little bit, but but anyway, so that never materialized. So yeah, we were there quite alone in 19-20 briefs on the other side, I want to say, something like that. So yeah.
Wow. That might be a record. 19 or 20 amicus briefs to one.
Yeah, that might be. Yeah, boy.
So I remember the moot. Mr. Fisher's alluded to the fact that he came down here before the oral argument in Tim's, and we did a moot court. Professor Scott was there, a couple of us. Was Professor Sanders part of that too? We should drag him in.
We should, yeah, right.
125, because all of us ought to be taking some of the blame.
Oh my God!
You're never going to moot here again, probably, after the performance we put on for you. So I think I already sort of know the answer to this because I was there when you were a few days before oral argument, but they weren't there.
Sure.
How confident were you as you approached the day of the oral argument?
In myself or our legal position?
No, in the possibility of winning the case.
Oh, not at all. No. No, we were under no illusions. I mean, there really isn't much chance that you're going to convince the U.S. Supreme Court not to incorporate a right. I mean, these days it's pretty difficult to if you look at the clauses that haven't been incorporated and the circumstances in which those cases were decided. It was a long time ago, a land far, far away. It just wasn't something that was going to be terribly easy for them to swallow. Our only hope really was to get them to take seriously the idea of overruling Austin. And even, like I said, that's such a heavy lift. We thought maybe we can get, if not a dissent, a concurrence, somebody to say something negative about Austin. We thought a footnote, maybe a wink and a nod. I don't know, something. But we were under no illusions. But you know what? We also never really took seriously the idea of just laying down and saying we're not going to argue it. Because, look at the situation. How did we get to a position where this has never been addressed before? Well, a lot of it has to do with states having their own excessive fines clauses that would take, a lot of the burden off the federal. But also, if you don't have states arguing, like we hadn't been arguing up to that point, these positions, then courts don't have a chance. And we saw it as part of our kind of our responsibility to push back as best we could so that the court would have a good chance to fairly consider this issue and make a declaration about incorporation. It just didn't seem right to kind of lay down and just everybody by acclamation declares incorporation. It just doesn't really seem like the system we have.
It now occurs to me, it never has before this moment, but it occurs to me, this is kind of like the stateside equivalent of what criminal defense lawyers often probably deal with, which is knowing your side's going to lose, but you still have a job to do. You have a responsibility to advocate for your client and make the best argument, and to the court, so that the court can do its job too.
There's also, there's also the reality that if we were to lay down and to say, you know what, we really can't think of a way to defend this against incorporation, that the Supreme Court would not be satisfied with that, and they'd find some poor amicus out there to appoint to argue it. I'll be darned if I'm going to let some amicus out there argue my position. If this thing's going to go down in a blaze of glory, it's going to be me at the helm.
So I will point out that the Supreme Court, again, part of the challenge, I assume, for you is the weakness of the position you're arguing. You've come up with some creative ways to kind of slice the issue to make it plausible. But you have to be honest, and you can't argue things that are not going to work.
Right.
And I think the court, in a sort of backhanded way, kind of acknowledged that in the opinion that you never actually. I think there's a line in the opinion that even the state does not seriously contest this or something like that. You were playing it straight with them. So, all right, how do you prepare as an advocate for an argument that, in essence, you pretty much know you're going to lose, at least on the merits of the issue that's been granted?
Right.
How does that affect your preparation?
Well, you have to have good humor about it, that's for sure. But it also, I think, kind of forces you to focus on if we're not going to win this case, and we're not, is there anything we can do to maybe lay the groundwork for the next case? To call, here that meant calling Austin into question, pointing out some really what we think of as very obvious weaknesses in that part of the doctrine. And if there's a problem with incorporation doctrine, is there anything that we can help them sort of realize about that to improve? And that wasn't really something that ultimately panned out very well. But calling attention to the weaknesses of Austin and trying to drill in the really uninterrupted history of in rem forfeitures up until the early 90s was something where we thought there's something to be accomplished there, that they shouldn't just sort of laugh off, this is some sort of desperate ploy, but should take seriously, if not in this case, then in future cases, that there is an important distinction between the in personam and in rem approach.
So I assume that's where this issue goes next. I mean, the incorporation question is now settled, 9-0, fine. Interestingly, there were two members of the court that, for whatever reason, chose to write separately to talk about whether to revive the Privileges and Immunities Clause. That was kind of exciting. But that I don't think is going anywhere either. No. So incorporation's been settled. I assume where it goes next now is back into the trenches in terms of defining what excessiveness means in this context.
Right. So we're back. We're on remand to the Indiana Supreme Court. They have, we now have a briefing schedule and another oral argument date set for late June, where we're going to argue about the issue that we actually cared about to begin with, which is how you measure disproportionality. And this is going to be an opportunity for us to talk about not only the weakness of using the maximum fine as sort of the benchmark, but also about the Scalia approach, for lack of a better term. Scalia.
Yeah, so explain to them what Scalia said about it.
So Scalia's view was that in rem, and this comes from Austin, in rem is part of excessive fines, but really, when you're looking at proportionality, what you really ought to be looking at is the connection between the property and the crime. In other words, this idea of instrumentality, and that's a fine way to look at it from our point of view. But we thought really that's a due process issue. Is there enough proof that this property really was an instrumentality of the crime? Either way, though, even if it's part of the excessive fines way of thinking about things, as long as we can prove that the thing was part of the crime, then we should win, and then it should be proportional.
So the Austin case, this older case we've been talking about from 1993, where Justice Scalia floated this different way of thinking about the excessiveness of in rem forfeitures, was kind of the extreme case that presents this issue. In Austin, a guy was doing some drug deals. He kept the drugs in relatively small-time drug deals. He kept the drugs in his house trailer, and the sting operation, the cops were showing up, the undercover cops were showing up at his business, like down the hill, which was an auto repair business. And he would then go back up the hill to the house trailer, get a little bit of drugs, bring it down to his body shop, and sell them the drugs at the body shop. And when he was convicted, the government seized both his house and his auto body shop. When the connection between the drug deals and these locations was somewhat tenuous, the fact that they happened to be stored there. Like it wasn't like the body shop was a complete front for a drug operation. It was a legit business that just happened to be the locus where the sale took place. Cars, I think, it's a little different, right?
Well, I mean, at least in this situation, I mean, he's clearly using the Rover to drive, every day just about to make these buys for his personal consumption and ultimately for resale, and then he drives the Rover to the resale. So it's a fairly straightforward connection, and so I think on the Scalia model, I don't think there's much question about whether it's quote unquote proportional. Now, is that the only way of looking at it? Obviously not. There are other ways of looking at it in terms of seriousness of the crime, the volume. Some judges would want to look at the volume of drugs, the number of counts of conviction, some obviously in our case the fines that could be or were levied. So and already around the country there are conflicts among courts about how to measure proportionality. So we're in the business right now of trying to convince the Indiana Supreme Court to take, if not the Scalia model, which would be sort of, our best, probably our best standard, then something that's also, more advantageous than this benchmark that the trial court came up with. Ultimately with an idea of, if not in this case, then in some later case, getting the Supreme Court to go back and look at, again, whether Austin should be overturned, and if not, then what really is the proper measure of proportionality. Because even in the Tim's argument, the Chief Justice and others were concerned about this, and Justice Alito, how does this make any sense to think about proportionality in this context when it's the thing, itself? You can't really just sort of divide up the property and say, well, this proportion of the property was responsible and this proportion wasn't. It's
we'll
just
forfeit the door.
The door, right? Exactly. Yeah. We can. You guys can take the tires, but you got to leave the Rover for Tim's. I don't know.
There was a question at oral argument about whether you can forfeit. Was it a Bugatti or something?
Oh gosh, the famous Bugatti. Yes. This is where moots are really, really helpful. Now, everybody likes to laugh at the Bugatti question. So this is Justice Breyer, and he asked, I can't remember if there was any preface to it, but he asked this question basically that boiled down to, okay, could you forfeit a Bugatti for exceeding the speed limit? Oh, and let's say it's only exceeding the speed limit by 5 miles an hour. And of course, my response was, what's a Bugatti? No, I said, but no, I've heard of a Bugatti. I was impressed with, although I shouldn't be surprised by the sort of the exotic reference from Justice Breyer, this very worldly guy. And I said yes. Now this had actually come up in the moots, not in the one we had here, I think, but the one I did at Notre Dame. It wasn't quite the exact same question, but the question I got there was, well, what about if somebody just parks their car in a handicapped parking spot and they don't have a plaque or they're not entitled to do that? Could you forfeit for that? And we had a go around about that. Okay, that seems really excessive. Whoops, don't want to use that word. And so we kind of went back and forth, and we came down to, look, you just got to go for it and say, yeah, that's perfectly fine under the excessive fines clause as we understand it, given the history of in rem forfeitures. If you can be forfeited this massive cargo ship for one person over the limit, then you can be forfeited for parking in the handicap spot, which then easily translates into forfeiting the Bugatti for going 5 miles an hour over the limit. So the way a lot of times it gets reported, in fact, the Wall Street Journal, I will add, the Wall Street Journal included a mention of this case 3 times on its op-ed pages within the week that it was decided. gee, I wonder who they were rooting for, But the way that they portrayed this was as if I thought that we should, forfeit the Bugatti for going 5 miles. Like, is this a thing, good, legitimate thing for the state to do? Well, okay, no. I mean, this is a very narrow question. Would the excessive fines clause prohibit that from happening? And my response had to be no, because our whole pitch was, if there is a violation of the law and the vehicle is an instrumentality of that violation, it is subject to forfeiture 100%. I can't back away from that, otherwise, my whole argument is out the window. So that's the story there.
So I want to wrap this up because I want to leave a few minutes for questions from the crowd. But I'm guessing that if you get the chance to go back to the Supreme Court on the merits issue as opposed to the incorporation issue, and who knows? I mean, the fact that you were there on this issue and you could be the one they would take again for the merits issue of what is an excessive in rem forfeiture. My guess is you're not going to have 0 states on your side when that case goes to the Supreme Court.
Yeah.
You'll have like 49 other states on your side. This is a big deal for states and for local governments. There's a lot of money involved in this, right? So this could potentially have a huge impact when you get to that.
Yeah,
that merits
that's
issue.
probably true. Although I will not want a brief that says, "Oh my gosh, Supreme Court, don't do something stupid here. We law enforcement agencies really depend on these forfeitures so that we can keep going and having." Bigger and better SWAT
Bugattis.
teams and whatnot.
We'll repaint the Bugatti as a police car, and that'll be great. No, I mean, seriously, this is actually, I'm not making that up. In certain parts of the United States, this is how police get the really cool equipment that they use to combat the drug dealers.
I was getting questions from media before and after the argument about, where's the Rover? Are you driving the Rover?
Right.
Where's the Rover? Who's got the Rover? Is it out there? Is the police using the Rover? What's going on with the Rover?
Right. So that will be a big deal when we get to that point. I'm going to give you a chance to say one thing about Supreme Court preparation. This is your fourth? This was your fourth?
My fourth, yep.
You want to tell me, did you win the others?
I'm now 2-2. So.
Okay. That's pretty damn good. What's the most interesting, enjoyable thing about preparing to argue in the U.S. Supreme Court?
I don't know. I think the immersion. To do one of these right, you just have to put everything else aside and completely immerse yourself in the subject matter. And I enjoy that. And I wish I could do it more in other cases. But this is sort of a special set of cases and a special practice that you have to know. You have to go in the courtroom thinking you know both the record and the law better than anybody else. And to do that, to get to that point. You have to just set everything else aside and read cases from the British common law and everything else in between here and there, and look at what are some of the debates on the coming out of the Civil War or during the Civil War in terms of who can be what confiscations can be made of rebel soldiers. I mean, all that stuff you have to know. I really enjoy that part of it. The best part, though, is by far doing the argument, because getting ready for it is both tedious and alarming and sometimes and quite humiliating, quite frankly. Not here, but here. I mean, I did a move here. I did one in South Bend. I did one in Indianapolis with some very distinguished lawyers, and then I did one in D.C. with members of the Supreme Court bar, people who argue there quite regularly, and they don't care who you are, where you come from. They are going to nail you hard, and that's really, really valuable. But it's also it's one of those where you kind of go back and say, "Wait, did I even graduate from law school? What am I doing?" But then when you get into the courtroom, because you've done all that and you're engaged in this dialogue with the justices, it is, I guess, it's so exhilarating, and I'm always looking for the next one because I enjoy it so much. So,
questions. Alex, you got just flip it on there if it's not on.
Hi, good afternoon. My name is Jose Moncada and I'm at 2L. I'm interested in the research aspect. What resources did you use, and how did you go about conducting that historical research?
I found this really helpful resource at Maurer named Alex Van Dyke, and we had a lot of lawyers and a lot of law clerks diving into treatises. Now, one of the interesting things about this case is that the old school treatises from the 19th century, very valuable. And these are treatise writers that, quite unlike today, were renowned not only for their ability to collect cases, but for their views on the law, and then what they would say about the law oftentimes translated into the law. And that became a huge resource for us to get not only their citations, but their analysis of cases so that we could cite those in the briefs. And that, without that, if we'd had to go back and sort of read all of the cases without knowing sort of any sort of analytical insights about them, that would have been a much taller order. But that was a huge benefit here. Not every case you can have the same set of resources, though. But you have to be prepared to just go dredge the swamp, and that's what we do. We dredge the swamp.
I think there was a hand in the middle.
Mr. Fisher, thank you so much for coming. Many of us here are in Sanders' constitutional law class, and so it was a really cool perspective to hear someone who argued a case we read a couple weeks ago. My first question is, did any of the Indiana Supreme Court justices apologize to you?
No, quite the contrary. Those justices, and I have to argue in front of them. They're my friend. They're my friends. And I argue in front of them regularly. I don't mean to belittle them at all, but they are still confident that the approach they took was the right approach in terms of just not deciding themselves, but laying that open for the U.S. Supreme Court to decide. So there we are.
And my follow-up is the point I still have a little bit of confusion about is this was in state court. Criminal proceedings. Every state has something on their constitution about this. Why did it get into the whole realm of the Eighth Amendment, Bill of Rights, federal? Why exactly did the court sua sponte bring that, make it a federal issue when it seems like it would be easily addressed in the state constitution?
That's a great observation. I think it's only because the trial judge never took my state con law class. The trial judge thought something looks amiss here. Right, there's something disproportionate. I don't like this. I know about the Eighth Amendment. I know about the excessive fines clause. Perhaps don't know as much about the state analog to that. And that became, I think, kind of the easier source of law to identify. And then it just took off from there. There was never any rechanneling of arguments. It just all kind of stayed with the Eighth Amendment. That's about the best way that I can explain it, I think.
I will point out there is, I think, one of the reasons I think this case had so much public attention, Wall Street Journal, et cetera, not because of incorporation. They don't care about that. What they care about is this bigger public policy question of governments, which have in many parts of the world increasingly begun to rely on the funds that they obtain from these kinds of forfeitures. I mean, there's a whole website devoted to showing how much each state makes from these forfeitures, et cetera, et cetera. So if you're looking at it in that perspective, it might seem like this ought to be addressed at the national level rather than having different states have different rules about that. I don't know. I'm just guessing. Other questions?
So this may or may not be a ridiculous question, but these cases tend to take obviously forever to work their way through the system. I don't know how long this was taken, but my thought process is for these in rem cases, especially when you're talking about a car, by the time we get done with all of this car may be worth $20,000. Does it matter at the end if it's not really disproportionate anymore?
Well, in fact, there was something about that in something I read that the car had devalued because he kept driving it so much. Yeah. He put like 24,000 miles in less than a year because he was shuttling back and forth between Marion and Richmond every day.
Right, and it's the nature of the beast with property, especially a vehicle that is going to devalue. Now, this thing, just for whatever it's worth, has been sitting, as I understand it, in a covered garage in Marion, Indiana. It's not like exposed to the elements. Tyson Timbs had an opportunity to come claim the Rover at one point when the trial judge ordered it released, and he never did. And then by the time, eventually, when we were on the winning side again, then it was never available. And so it was sort of an odd thing. And then he's actually said in interviews that he's long in his own mind kind of written off that he'll ever get the Rover back. The case kind of continues on because it has a lot of value as a vehicle for getting results on the doctrine. In terms of the overall value of it now versus when it was forfeit, I don't know. I mean, it's a great point. I have no idea what it would get. Perhaps because it is the car associated with this incorporation case, it will have greater value than you even imagine.
It'll be in a museum of incorporation.
Right. The Institute for Justice, who's Tyson Timbs is a public interest law firm. They do great work and they win lots of great victories. So they're probably going to have a Hall of Fame. They're going to have their food trucks. They're going to have their hair braiders. They're going to have their Tyson Timbs Rover. I mean, they would really have, I think, a really neat. They should do that. I don't know. Maybe I should suggest that.
I'm Michael Osbrook. I teach the federal habeas clinic here, and I was wondering, so you get the news that the Indiana Supreme Court has punted and said, we're not going to touch the excessive fines clause. I assume that part of it was, if that's the first time you heard about it, then some line deputy attorney general litigated the case. And why don't you jump in and then say, whoa, Nelly, Supreme Court, actually you should say, every other court to have considered this has assumed without deciding that the excessive fine clause applies. You should too, and you can even say the state excessive fines clause does the same thing as the federal, but this fine is not excessive.
I think we had certainly made the last point quite clear in our arguments. I think given the way the opinion was written, they knew what they were doing. There really wasn't a chance to go back and say, well, you sort of missed something here. It was quite clear that they knew the lay of the land and that I don't know. I've never heard them say this. I suspect that they thought if we go this certain route, then this maybe can be the case where they do this. So I didn't think there was much chance that on a rehearing that they would go back and redo it.
I mean, one of the reasons I ask is that you weren't optimistic about your chances of success, and if you look at what happened in your case, it's a lot like what happened in the United States v. Hubble, where the government took a really indefensible position, and Justices Scalia and Thomas at the end of that opinion said, oh, and by the way, if it would have been presented, we'd revive Boyd from 1886. And so, in your case, you got the two concurrences saying, oh, and by the way, the Privileges and Immunities Clause might be in play here.
Do you expect that to come up?
Yeah, I
did. Ready for that?
I did. Oh, yeah. And we never took it. We figured that Justice Thomas would be continuing because that's a position he staked out in the past. We thought there was a decent chance that Justice Gorsuch would align himself with that position. But we never took seriously the idea that it would get any more than those two. And I mean, at this stage of incorporation, why go back and sort of redo everything? By the way, just so everybody's aware, the court has now taken yet another incorporation case for next term from Louisiana on unanimous jury verdict.
Yes. I'm glad you brought that up. So let me just very briefly, because it's important. So one of the issues in incorporation back in the day, like before we were born? No, I'm just kidding. Before you were born, not before I was born, was when a right gets incorporated, does it have to apply to the states in the same way that it applies to the federal government? This is the old jot for jot incorporation issue. And interestingly, although 8 out of 9 justices took the position back then that it does have to apply the same way, which is why you couldn't get away with arguing that Austin meant is one thing for the feds, but should mean something different for the states. 8 out of 9 justices said it has to apply the same way when it comes into the states. One justice didn't agree with that, and because the other 4 in the jury unanimity case, when jury trial right got incorporated, 4 justices said it's got to be done the same way in the states as we've always done it in the feds, and that means unanimous juries. 4 others said it's got to be done the same way in the states as we've always done it for the feds, and we don't think it does have to be unanimous juries. And then Justice Powell said, I think it can be different for the states and for the feds. I think it has to be unanimous for the feds. I think it can be non-unanimous for the states. And because he got 4 for each of those positions, jury unanimity has never been required in state cases. That's the one the Supreme Court just granted, and we'll hear arguments on next year.
Louisiana is the state that found itself in that lucky position. since the time that this particular defendant was convicted, have done away with non-unanimous jury verdicts. So that all they have at stake is this one conviction. There's only one state left that has non-unanimous jury verdicts, Oregon. Now, I want to see that amicus brief. I want to see Oregon, one of the most progressive states in the country, show up with an amicus brief that says no incorporation on unanimous jury verdicts. We'll see.
Yeah. One question before we wrap it up. Okay. Michael.
Yes, excuse me. I actually was here for the moot when you came down, and I remember there was a bit of back and forth about kind of, well, we might get Justice Thomas and Justice Alito is fond of this type of argument. I just wonder if you could comment, and not just for this case, because I understand it was kind of a steep hill to climb to begin with, but for all of the cases where you've gone in front of the court, how do you tweak your arguments or how you frame things based on specific justices and sort of keeping that all in balance?
Well, it's something that you have to constantly be reading all of their opinions to understand where they are in various doctrines, because it's not just a function of sort of their broad philosophical outlook, but what commitments and what suggestions have they made in majority opinions, concurrences, dissents, when they were lower court judges, et cetera. I will share with you in a very high level of generality that right now we have a case going on that's in the district court. It's just barely out of the gate, and already our strategy in the case in terms of how we're going to prioritize arguments turns on, if this gets to the U.S. Supreme Court, where do we think these justices are going to be? Do we want to take a risk of winning on an argument that maybe some of them won't like, and then maybe it's a sort of Pyrrhic victory? So I think we try to take all of that into account as early as we can, and it just requires being kind of up on what their writings are.
I want to thank our guest today, Mr. Tom Fisher, one of our great alums and a supporter of the law school. And also Alex for helping in every way to set this up. Thanks, Alex. And thank you all for coming. If you have any questions about the Bradley Fellows Program, get in touch with me. Come talk to me. Thank you. Thanks, everybody.